Mr. Guthrie.
My Lords, the reference the respondent, Simon Pringle, was represented by my own friend, Mr. Scott, Mr. Collins, and Mr. Page. My Lords, as you know, is a reference under Section 4 of the 1833 Act. Somewhat unusual and unfamiliar territory, I suspect, to many of us. But we have done our best to ensure that you have the necessary material.
On the question of unusual and unfamiliar territory, I think Lord Reid is about to bowl you both a ball.
Well, it may be a rather difficult ball for you to deal with off the cuff. Lord Hodge and I have both been doing some research on this and have reached some provisional conclusions, which might affect what usefully we can discuss today. It seems to us that the baronetcy that we're concerned with is a Scottish baronetcy. There's quite a lot of material in the Scottish textbooks and cases about this subject. It has a particular bearing on the question whether the right claimed by the applicant might have prescribed. There is a Scottish statute that deals with prescription, the Prescription and Limitation Scotland Act of 1973, and there's a provision in it, Section 8, which establishes a 20-year prescriptive period for rights which are not exercised or asserted. Now, there might be an issue as to the interplay between, as to how, if at all, that section applies in relation to the requirement imposed by Edward VII's warrant to make a positive assertion of your claim to the baronetcy. Now, the views we've reached about this, I should emphasize, are provisional because we've had no submissions on the point in either party's case for reasons which, when one sees the authors of those cases, is not very surprising. But there are matters that I think we do need to have submissions on. And so there may be a question, really, as to, first of all, what we should do about receiving submissions on that aspect of the case, which I imagine would probably require the instruction of Scottish counsel. But that leaves over issues which are a matter of UK law, or law at any rate where there's no relevant difference, particularly the Data Protection Act, and the issue about an alleged breach of confidence. So it may be there are some matters we can more usefully discuss today than others.
Well, I think if this helps, this is obviously, as far as you're concerned and those instructing you are concerned, something of an unexpected turn of events. I assume it is, judging by your written cases. What I was going to suggest was that it seemed to us, having discussed this with Lord Reid and Lord Hodge, the rest of us this morning, that one sensible course to take, as Lord Reid suggests, is to discuss the data protection and breach of confidence issues, but to adjourn the prescription limitation issue, on which I imagine you would both want to get advice from counsel or advocates north of the border, and then to have a timetable for written submissions on that, following which, unless the answer is pretty clear, it would seem appropriate to have a further hearing. But I think probably the most sensible way, I haven't discussed this with my colleagues, but the most sensible way to proceed immediately is, with that possibility on the table, to adjourn briefly so you can discuss it between yourselves and take instructions. But I don't think it should take very long. But I think rather than, as it were, negotiating without instructions and without having you talk to each other would be a recipe for possible confusion. Does that seem sensible?
I think we'd probably both be grateful for a moment, yes.
Okay. Well, I would certainly say no more than 10 minutes.
Yeah.
And if you're ready earlier, let us know. Thank you very much. We'll adjourn now. Court's adjourned.
Well, my lords, thank you for the time. I suppose this is traditionally the moment when council say they're grateful for the early intervention by the board. Usually one's tongue is more or less in one's cheek at that point, but it is obviously rather unfortunate that events have taken this turn.
Well, we are where we are.
Well, indeed. For our part, we had taken the precaution of running the position past lawyers north of the border. Regretfully, they didn't raise the point that has now been raised, but I think we both accept that the matter will have to be adjourned at some stage so that it can be properly researched.
I mean, as Lord Reid says, we haven't heard argument. It may turn out to be nothing in the point, but given that we are concerned about it, and there appears to be, well be, clearly we have to deal with it.
Exactly. The provisional answer which one might give would be that prescription doesn't arise and that the situation has to be considered afresh on each claim to the baronetcy under the provisions of the Royal Warrant of Edward VII. And
when the person entered on the roll has died,
yes.
it's a fair game again.
Yes, it is, that is the effect. I mean, well, I was going to come to that at a fairly early stage of my submissions in any event, but perhaps before I do so, I should start as though this...
well, the question really is, should we put the whole... should we just deal today, subject to being corrected, with the Data Protection Act and breach of confidence?
Well, I would
put the whole question of prescription and limitation on one side.
We should certainly put prescription and limitation on one side. I accept that, but I would not accept that we were left only with the question of breach
that's what I was asking you.
And data protection. Lord, I was going to begin, and indeed do begin now, having put those matters to one side, but by, I suppose, a statement of the obvious, which is that a reference before your lordship's board is somewhat different to an appeal.
I understand.
Well, the first, and again, apologise for mentioning something so obvious, is the difference that the board does not have the benefit of any earlier judicial consideration of the issue, which normally an appeal would have the judgment of first instance and the judgment of the Court of Appeal. It was as a result of that that Mr. Scott and I decided it would be most helpful to exchange our written cases and then subsequently to exchange our responses.
Very helpful.
But I think that has meant that your lordships probably have more written material than you would normally expect, and we have been able to develop our arguments at perhaps somewhat greater length than might otherwise have been the case. But I would like to start with, as I say, a brief reference to the basis upon which the matter has reached your lordships. And I was going to raise as a very first point the fact that the succession to a baronetcy is not automatic, and that the situation is regulated by the terms of the royal warrant made in February 1910 by King Edward VII. And your lordships have that in the record at pages 13 and 14.
Thank you. Yep.
It appears, by way of background, that the assertion of entitlement to baronetcy being made at the beginning of the last century by persons who had no right to do that. We see on the first page of the Royal Warrant, in about the 5th or 6th paragraph, that divers abuses have crept into the situation. And it is then that the official roll of the baronets is prepared, that's item 1 of the order, that no person whose name is not entered on the official roll of baronet shall be received as a baronet or addressed or mentioned by that title. The roll, item 3, shall be prepared in consultation with one or other of the kings of arms, Lion, Garter, or Ulster, according to their respective heraldic jurisdiction.
Yes.
The next words perhaps of some importance, that such roll shall be revised and corrected from time to time, and shall be submitted to us and to our successors once in each year, published annually. Any person whose name does not appear on the roll, but who considers that he is entitled to the roll thereon, shall be at liberty to petition us through our said Secretary of State. Every person who shall succeed to the title shall exhibit his claim to such succession with the proofs thereof to one of our kings of arms according to their respective heraldic jurisdiction. And if in any case or in any circumstance whatever our Secretary of State finds difficulty in advising us as to the validity of the claims of any person to be placed or to be retained on the roll, he shall refer the matter either to our Attorney General, to the Lord Advocate for Scotland, or to our Attorney General for Ireland for his opinion thereon, and may, on consideration of that opinion, direct that the said matter be referred to our Privy Council to submit the same to consideration and advise us. Then there's a provision as to costs, the item 8, subject to the directions of our said Secretary of State, the Registrar of the Baronetage shall be charged with the duty of keeping of the roll and of making all necessary entries and deletions in it, and of publishing the roll annually, shall be responsible for its contents, etc. In the present case, my lords, when it became apparent that there were two persons claiming the baronetcy, the registrar was consulted and a caveat was pasted on the official roll. There was what might be called a false start in the family division, but after that the parties agreed that the applicant would submit his claim to the registrar or the Lord Lion King of Arms, it being, as we know, a baronetcy of Nova Scotian creation, so within the Lord Lion's ambit of jurisdiction. The registrar referred the matter to the Lord Chancellor, and who the Secretary of State, in other words, referred to in the Royal Warrant, and in turn he referred it to the Advocate General for Scotland and to the Lord Advocate in Scotland, and after consideration those three officials advised the possibility of a reference by Her Majesty under Section 4. And that is how the matter is now to be resolved. My Lords, just for your reference, the history of how that came about is set out in some detail in writing in the applicant's case, which you will find in the electronic record at pages 460 to 62, and in paragraph 25 of the applicant's response at page 518.
But while we have this in front of us, Mr. Guthrie, would it be fair to say that it rather looks from Article 3 in the second paragraph, every person who shall succeed, and similarly Article 10 and Article 11, every person who succeeds, every person who, after the date of his presence, succeeds, that this warrant doesn't affect succession to the title at all, but is concerned, as Article 2 indicates, with the official recognition of the title.
Well, I think that would not be quite right with respect, my Lord, because the purpose of the warrant was to ensure that the succession was correct. Not only that persons should not assert themselves as baronets who weren't, but in each case, the practice is that the succession must be proved. And the succession to a baronetcy, as we see, does not depend upon mere transmission from father to son, but on compliance with the terms of the original grant. So, in other words, that is the question which one has to answer, and we'll come to see that when one looks at the cases in a moment.
But on the face of it, as my Lord says, paragraph 2 is concerned with official recognition. Yeah. I mean, that's probably what matters, actually, ultimately.
Well, that is indeed what we're seeking, because the terms of the reference are who is entitled to be entered on the roll of the baronetcy.
And you make the point that it can be revised and corrected under 3.
Indeed. Well, that is expressly envisaged.
No, quite, that's what I'm saying.
And indeed, we know that the background to the warrant was the fact that certain baronets, so-called, were not entitled to be baronets as a matter of law, and indeed one of the reasons for that would be as a matter of hereditary succession.
So you say, in effect, in answer to any prescription point, although when I'm trespassing on the Bay Area, I said should stop, is that this is really a rolling warrant, as it were.
Indeed.
And any time somebody...
Well, certainly the view taken, as you've seen, I think also from my case, by the standing counsel of the baronetage, currently headed by Sir Simon Watson, is that a baronet must prove his entitlement to the baronetcy whenever the baronetcy, so to speak, falls vacant on the death of a baronet. And indeed... so
if there is your point is if there is a prescription point,
yes.
the prescription period starts running on each death.
On each successive death.
I would have thought myself, just reading this warrant, that the applicant's position would be that he is the baronet,
Yes.
and he's seeking to have his title recognised officially in accordance with Article 2 of the warrant. He's not saying, please make me a baronet.
No, that's exactly right. That's exactly right.
Who was the baronet before, immediately before this statute? Immediately before February 1910.
The baronet immediately before February 1910, well, there was no baronet entered on the roll because the roll did not exist at that time. That would have been the 8th baronet because he did not die until 1919. And he is the baronet who everyone accepts was properly so-called, properly entered in the roll, and who was the heir male of the body of the first baronet, Robert Stichill.
So on anybody's case, it was the 8th baronet then?
Yes, it was the 8th baronet at that time.
1897.
And perhaps the questions of prescription should be left, but
There's concern with status and preventing the assumption of those with no rights. Yep.
yes.
Presumably your client's position would be that he became the baronet on the death of his father having been the baronet
Yes, indeed.
before him.
That is his position. And indeed, as part of the relief which we seek is not only the correction, not only the entry of the of my client Murray on the official roll, but the correction of the roll of the baronetage to show that his father was the 9th baronet, as opposed to Sir Stewart as the 10th baronet, and Sir Stewart's father as the 9th baronet.
It may turn out that this issue is not determined by Scots law and the prescription and limitation Scotland Act 1973, Section 8 issue, but it may turn out to be a UK-wide issue as to what the warrant means.
Yes.
Certainly that
yes.
will be a highly relevant issue because the sort of points we're discussing now are concentrated
Well, it's
more on the
probably
warrant.
better if we were going to leave the prescription issue.
But I think that
yes.
it's a useful discussion that identifies that it...
Well, I've indicated
You have-
probably where we will be coming
very
from in due course, but
It's very helpful.
but subject to further submissions if necessary.
Yes, I mean, one question would be whether His Majesty in 1910 was concerned to extinguish baronetcies, or whether he was just regulating their public recognition and addressing the abuse of people assuming the title of baronet.
Well, I
He was safeguarding
don't
the
think
status.
there's
He wasn't trying
any
to get rid
evidence
of
to
the state.
suppose that he was anxious to extinguish baronets.
Well, I mean, that would effectively be one view of this, that if you're not registered, it's gone forever. But the alternative is probably, is a less extreme one.
There also may be an issue if the consequence is, in Scots law, if the analysis put forward as a possibility by Lord Reid before we adjourned is the correct one, it might, if it was correct, result in a different consequence for Scottish baronetcies from English baronetcies, which would be possible, but possibly slightly surprising. So again, we're trespassing in areas, but I think it's worth going into it simply so that everyone's aware of the possible implications of the issue.
There are 5 sorts of baronetcy, which I think I've listed.
Yes.
I'm bound to say I had no idea of any of this before.
I must admit,
but it is the case. I have listed them in the in the document.
So just to make sure I understand, your position is that your client has been entitled to be registered as baronet on the official roll of baronet since 1968, the death of his father. Is that
Yes,
right?
the death of my client's father.
The death of your client's father. Yes.
Yes, I think that must be right.
Yes.
And indeed, yes, that must follow.
Yes, and but when we adjourn, sorry, last point, when we adjourn to deal with, to enable you to deal with these issues in writing, I would be very keen on having a timetable so that we know, and you each know, when each of you has to produce your submissions, and I think we should have written counter submissions, so that we have a timetable for that.
Well,
again, I'm not asking you to deal with that now. But,
no, my lord, we've already mentioned the matter to your registrar. She brought it up with us.
well, no, if there's going to be another hearing, when it's a different point, I just want everybody to go away knowing when their submissions and counter submissions on this issue have to be in. But you needn't deal
Well,
with that now.
we would prefer that too.
Fine, you can discuss that over the adjournment. Yep.
Yes. Having shown you the warrant,
Yes.
I was going to continue to make some reference to the basis upon which the matter comes before you as a reference. It's probably not necessary to look at it because the most recent cases involving references have been on entirely different sorts of subject. In fact, my Lords Lord Newburger and Lord Mounts may recall a recent reference from the Cayman Islands, which in fact you declined to deal with on the basis that it was better dealt with under ordinary judicial review procedures. But there is some small assistance as to the approach which is made on a reference in that case, which I've set out in our response. But it's paragraph 35. Unfortunately, the case did not find its way into the bundles.
If it's quoted in your response.
It is quoted, but there's a citation from a speech made by Lord Hailsham in the House of Lords, saying that a reference was a convenient way of ascertaining the law where there was no other obvious venue. And in the present case, that is exactly the situation, because although there was a standing committee from the baronetage, for the baronetage, a standing committee of the Privy Council, it no longer exists, and in fact it last sat, my lords, in 1927. But what I derive from the situation of a reference is that it is not the same as a straightforward inter-parties appeal and litigation. And that is relevant to your lordship's approach to the issue, which is not a matter of a private, or not just a matter of a private dispute between the applicant and the respondent as to who is entitled to be entered onto the roll, but it's an investigation as to who is entitled to be entered on the official roll as a matter of the law of hereditary succession, which affects not just these gentlemen, but also their immediate ancestors and also their successors. And that may affect the approach when we come to consider whether or not there's any justification for refusing to admit relevant evidence.
Well, that would also be relevant to other questions of succession to dignities and titles of honour, at the very least.
Yes, indeed. Yes, it will be.
I mean, peerages, which...
I'm sorry?
Peerages.
Well, peerages, certainly. I mean, some of the authorities which we're going to show your lordships involve peerages. But
Where's the quotation that you referred to?
Paragraph 35 in the... paragraph 35 of the authority. It's in the response, and I think paragraph 25 or 24.
Which number?
That would be...
Electronic page number, I mean.
yes, indeed. That would be 518.
Thank you very much.
it is an opportunity, and we say your lordships would be examining the law of hereditary succession beyond this case. And that would be a matter which should be borne in mind when looking at questions, for example, of the admissibility of evidence. My lords, I was next going to ask your lordships to consider the issue which your lordships need to decide in order to be able to answer the question which is posed by the reference. Who is entitled to be entered on the official roll, which depends on the law of hereditary succession. Sorry if that's another statement of the obvious, but in the exchange of cases, it has been revealed that there is a fundamental issue between the parties, which I should probably address straight away. Well, in paragraph 27 of the applicant's case, we say that the issue depends upon whether or not Norman Hamilton Pringle was or was not the 8th baronet's lawful and natural son. Conversely, in paragraph 35 of the respondent's case, it is said the issue which is before the board is not whether Sir Norman was the biological son of the 8th baronet, but whether he should be regarded in law as the legitimate son of the 8th baronet.
Paragraph, sorry.
It's paragraph 35 of the respondent.
35.
In fact, the two quotations are set out at the very beginning of the applicant's
I have
response.
it. Thank you.
But, my lord, we should say straight away that we don't accept the respondent's formulation of the question is right. The law of hereditary succession only permits the title to pass from a father to a son if the son is the natural biological son of his father. Otherwise, the son is disqualified under the law of hereditary succession.
Right.
And that is because, my lords, the succession must follow the destination established by the original grant, which in this case is limited to the original grantee, Sir Robert Pringle, and the male heirs of his body. And your lordships have the original grant in the record at pages 4 to 9, first in Latin and then in an English translation.
Can I ask Mr. Guthrie, in relation to the reference under Section 4, the claims to Scottish baronetcies are quite often dealt with in the court of Lord Lyon.
Yes.
For example, one could petition to matriculate arms as Pringle of Stichill.
Yeah.
Is there any particular reason why that procedure hasn't been followed?
It has been followed, my lords. Lord Lyon found himself unable, so to speak, to deal with the matter, and that is part of the story as to how the matter has reached your lordship's board. Originally, as you'll see from the correspondence in due course, it was thought that this would all be dealt with by the Lord Lyon. Then that proved not to be possible. As I say, there was something of a false start in the family division, but the parties then agreed that the matter would be treated with by the registrar here and or the Lord Lyon. And indeed, that is what happened, and the Lord Lyon was approached again. And I understand it, among other persons, on his advice, that the situation has reached your lordships. I had just asked your lordships, I think, to look at the words of the original grant. The translation is on page 8 of the record, and the important words are, "and his male heirs from his body." And, Lords, what that means is his natural and biological son, and not anything else. We have included some material about this in our written case at paragraphs 7 to 11, which I think will be in the 460s of the electronic copy, but we've referred to Palmer on peerage law. The Lordships have that at paragraph 34, and so divider 34 of bundles, if you're working from the paper copy, which is at 1719, if you're working from the electronic copy.
Yes.
This
is peerage law in England, and I'm dealing neither with peerages nor England, but never mind.
Well, yes. I don't think I'll be taken up on there being a distinction between the meaning of the words either side of the border here. But
sorry, what tab is in?
It's tab 34.
A practical treatise.
I'm sorry?
A practical treatise for lawyers and laymen.
Yes. Well, interestingly enough, Palmer was also the Palmer who wrote the first companies law, so he obviously had broad interest. But he was, and also interestingly enough, my lord, I was rather surprised to find that it is still in print, and have a copy. But at page 64, which is this first real page of the extract, you will see the quotation, middle of the page, frequently found in use in peerage charters and grants since Norman times. Certain technical expressions, for example, a grant to A and his heirs, to A and the heirs of his body, and to A and the heirs male of his body. Each of these expressions has, and has for many centuries had, a well-understood meaning when used in relation to the grant of hereditament. They were and are words of limitation defining the quantum or extent of the estate granted, and the lines on which the hereditament is to travel in its descent. In other words, there are legal limitations with a proper technical meaning, and if in construing any particular charter or letters patent, it is sought to displace this meaning, the onus of proof rests on those who seek to attach to the words another meaning. Prima facie, the technical meaning is the proper meaning. I have also set out what we conceive to be the principle in paragraph 10 of the applicant's case, which is that the words limit the line of descent to the most senior, lawful, and natural biological male descendant of the grantee, and thereafter to subsequent descendants of the grantee according to the same formula upon the death of each subsequent heir.
And I suppose what you'd say about all the law relating to how you proved paternity is just a question of evidence.
Yes.
And so all of those rules about presuming that a child born to a married woman was her husband's child, and the difficulty of disproving that actually doesn't affect the person entitled. It's just a question of how you prove.
Yes.
And now we have different methods of proving this. We can apply those methods to this definition of the person we're looking for.
That's exactly the way in which we put it, my lady. And my lady, just before leaving the proposition, your ladyship mentioned that this was a book about peerage law. So far as these principles are concerned, there is no distinction between baronets and peers, although, of course, they are not subject to the Committee of Privileges of the House of Lords.
Subject to your point, subject to the point you've got to answer about the warrant, you say Chapter 13, time no bar, applies to baronetcies.
Yes.
And
Indeed, it seems to be generally a proposition, and indeed, well, without attributing it, our Scottish law simply said that that was the law. I mean, there's no question of prescription in relation to hereditary titles. And we'll obviously be coming back to that in due course. But I have given in paragraph 11 of our case a reference to Halsbury,
Yes.
the 5th edition, which is at divider 31, paragraph 808, which refers to the fact that a hereditary peerage is it's divider 31, it's page 1680 in the electronic reference.
Yep.
A hereditary peerage is an incorporeal and impartible hereditament, inalienable and descendable,
Yep.
according to the words of limitation contained in the grant. A baronetcy is not one of the degrees of peerage, but it is nevertheless an incorporeal hereditament, descendable in accordance with the grant. And the case in support of that is said to be in Re Rivet Carnack's will, a case from 1885. Well, I don't think it would be worth taking your lordship's time to look at that. It simply does what Halsbury says it does. It establishes that a baronetcy is what Halsbury says it is. And, my lords, that, I think, takes me to what may prove to be one of the more significant authorities which your lordships will need to look at in the case, which is at divider 4 of the authorities bundle, and manuscript, MS page number is 857, and it's a case called Dunbar of Kilconsey and the Lord Advocate. And it's perhaps worth taking a little time to look at it because it is relevant to more than one of the issues which arise. If I can just give the background, in 1694, the baronetcy of Dunbar of Mockram was created by grant of letters patent with a destination to the heirs male of the body of the first baronet.
Yep.
So the same as our case. In 1953, the petitioner's half-brother, the 11th baronet, died. The petitioner would have thereafter been entitled to succeed to the baronetcy had he been legitimate. He was not then legitimate under the law of his domicile, England, or under the law of Scotland, as at the date of his birth. His father had been married to a woman who was not his natural mother. The petitioner's cousin assumed the title and matriculated the plain undifferenced arms of Dunbar of Mockram with the baronetical additaments, and thus came to be recognised as the 12th baronet. The petitioner came to be legitimated under English law in 1959 in terms of the Legitimacy Act 1959, and under Scots law in 1968 in terms of the Legitimation Scotland Act 1968. The 12th baronet died in 1977, leaving a son, the second named respondent. In 1982, the petitioner presented a petition to the Lord Lion for matriculation in his own name of the arms of Dunbar of Mockram, so as to demonstrate his succession to the baronetcy in at least 1968, when his legitimation came to be recognised under Scots law. The petitioner argued that his cousin's right to the title had vested in him only subject to defeasance, and in any event, when succession to the title opened up on his cousin's death, the petitioner alone possessed the character of the heir male of the body of the first baronet, and accordingly, the right to the baronetcy title in terms of the instrument of the letters patent creating it. The court of the Lord Lion dismissed the petition as being irrelevant. The First Division refused the petitioner's appeal from that decision. The petitioner thereafter appealed to the House of Lords. And it was held, considerations of reason and justice favour the conclusion that the petitioner's legitimation so long after the succession rightfully passed to the junior stirp should not result in its reversion to the previously extinct senior stirps unless that result was compelled by some specific provision of the 1968 Act. That Act was careful to avoid any retrospective effect and insofar as there was no clear contrary provision, should not be so construed as to disturb legitimate expectations. And 3, that the time for the petitioner to succeed to the baronetcy, if he were to succeed at all, was on the death in 1953 of his half-brother, the 11th baronet, the 1968 Act not conferring upon him the right to succeed at some later and unnatural time, not contemplated by the grant of the letters patent, being a right which could not possibly have been available to an heir who was throughout legitimate, and the appeal was dismissed. And my lords, can I just refer you to certain particular passages? First of all, on page 7 of the report, page 863 electronically, the pleadings of the petitioner are set out. The petitioner, being the son of Richard Taylor Dunbar and having been legitimated in England, asked to be, said that he became, and that word may be important, the heir male of the body of Sir James Dunbar of Mockram on the 29th of October 1959, or in any event on the 8th of June 1968, and thereby succeeded jure sanguinis without requirement for service or other procedure to the name, arms, supporters, and baronetcy of Dunbar of Mockram, etc. Now, the second respondent pleaded, the petition being incompetent should be dismissed. The petitioner's right to assert the present claim having prescribed, the petition should be dismissed. The petitioner's averments being irrelevant, et separatim being essentially lacking in specification, the petition should be dismissed. The petition's averment, so far as material being unfounded in fact, the prayer of the petition should be refused. The subjects to which the petitioner lays claim and the right to succeed having become indefeasibly vested in another person in 1953 or in 1954, in any rate prior to 59, the prayer should be dismissed, and the prayer of the petition should be refused, and prescription was again raised. Well, then on page 8, under the subheading relevance, you see the Lord Advocate and the respondent had lodged identical pleas in law,
This is reading from the judgment of the Lord Lion, I think.
Yes, this is the judgment of the Lord Lion. In fact, it may not be necessary for me to read that. Having set out the parties' positions, I would like to go, if I may, to page 10 of the report.
Yep.
Where you will see that the argument of counsel for the Lord Advocate and the respondent at the foot of the page argued that the effect of the subsection with regard to the law of Scotland, the petitioner, was until 28th of October 1959 to be regarded as an illegitimate child.
Yes.
Because that is the basis upon which the petitioner failed, was because he was not entitled to succeed at the time the succession opened up.
To be judged on the question of when he would have succeeded if he'd been legitimate.
Yes, and he wasn't. So that is why he lost. But in fact, you see at the foot of the page, the petitioner cannot, as it were, cleanse or legitimate the blood between the death of his half-brother on the 25th of January 1953 and the 29th of October 1959.
So in other words, it had to have been legitimated on or before 25th January.
Yes, in other words,
53.
in other words, it was perfectly all right for the junior Sturps to inherit because they were the proper persons at that time, whereas the pretender, if I can call him that, wasn't, because he was filius nullius at that time. But the
fact that that was subsequently revoked doesn't alter that fact.
Didn't alter that fact. But that's obviously different to our situation. But there are some further, perhaps helpful observations in the judgment. In the judgment of the Lord President, Lord Emslie, which is at page 11 of the report, 867 of the thing, the petitioner's proposition is recited. The proposition was that by virtue of his legitimation in England, he became and failed to be recognised in Scotland as having become on that date, or in any event the 8th of June 1968, the heir male of the body of the first Baronet Sir James Dunbar, and thus to have succeeded to the baronetcy on one or other of those dates. The difficulty that he sought to overcome was that a man now deceased, but with issue of a son, has already matriculated the achievement of arms, and his object is to displace it. And then really further development of the reasoning, which I think your lordships are already aware of. The summary is on page 13 of the report, about 2/3 down the page. It follows, since it is common ground that the right to a title such as a baronetcy arises juris sanguinis in the person entitled to succeed in accordance with the terms of the particular destination, that the petitioner's claim now is that he became, on the 8th of June 1968, the heir male of the body of the first baronet and succeeded to the baronetcy on that date, unless that claim is defeated by Section 2. So I rely on the first part of that passage. A right to a title such as a baronetcy arises juris sanguinis in the person entitled to succeed in accordance with the terms of the original destination. And the judges were at pains to distinguish the situation with the missing heir type of case, where the person who subsequently appears and claims the title was indeed entitled to succeed at the relevant time, but nobody knew he existed, or for some reason the title passed to the wrong person.
Yeah, you say it's to be judged at the relevant time.
No, I say that the distinction with this case is that at the relevant time, my client's father was the rightful person.
I understand.
Yeah. But if I could just ask your lordships also to look at pages 22 and 23 of the report. This is, first of all, the extract from the argument before the House of Lords, where the case ended up. And the part I've highlighted is at page 22, and it is part of the petitioner's argument, which had been decided against him by the First Division, but was decided in his favour by the House of Lords. And it begins really a little over halfway down the page. If your lordships see a reference in italics to Major Henry James Sholto
Yes,
Douglas.
at the end of the line, yes.
Just below that.
Right.
In any event, as to the meaning of heirs male of the body in the letters patent, it is a general rule of Tales's succession that on each occasion when the succession opens, what matters is the relationship to the institute and not to the last holder of the title. And then there are a series of cases. And then the argument continues. The question is who today is the heir male of the body of the first baronet, of the institute in the letters patent. The question that one does not ask is who is the heir male of the last holder of the title, albeit these will usually be the same person. The question is not just restricted to titles and dignities, it would apply equally to land in an entail. Accordingly, when the succession reopened in 1977, the appellant failed to be treated as the heir male of the body of the first baronet, and therefore entitled to succeed to the baronetcy in preference to the second respondent.
Yes.
And that argument didn't succeed because, for the reason that your lordships know, he wasn't, at the time the succession opened up, the heir male of the body of the first baronet. But if I can just also read the argument for the Lord Advocate at page 23, at the foot of that page, it is essential to have in mind at all times the terms of the destination contained in the letters patent creating the baronetcy.
Sorry, where is that?
It's the last paragraph on page 23, page 879.
Well, the one beginning argued for Lord
Yes,
Abbott.
indeed, and the second named respondent. It is essential to have in mind at all times the terms of the destination contained in the letters patent creating the baronetcy, whereby the succession to the title and arms has at all times been and still is regulated. The destination was in simple and straightforward terms James Dunbar and the heirs male of his body, and was untrammelled by any destinations over conditional institutions or other complicating features. Against that background, the First Division correctly recognised that the whole of the appellant's contentions, whether his position was examined during the lifetime of the 12th baronet or at the date of his death in 1977, depended upon the essential premise that the appellant became, on the 8th of June 1968, the heir male of the body of the first baronet. The First Division, in common with the Lord Lion, correctly found the essential premise was not established. The terms of the destination in the letters patent are such as to require the title and arms to pass down a continuous line of legitimate descent through a series of male heirs, each tracing his legitimate connection directly and without interruption back to the first baronet. The appellant was in law filius nullius at birth and was still filius nullius at the date of his natural father's death in 1940, and also at the date of death of his natural half-brother, the 11th baronet, in 1953. The act was not retrospective, so that was sufficient to defeat his claim.
Am I right in thinking, obviously it must be the case, and I've only just been glancing through, whereas the English Legitimacy Act excluded titles and dignities of honour from its operation, the Scots Act clearly didn't.
Yeah, that's right.
If it followed the English model, none of this problem would have arisen.
Yes, that's right.
Yes. Although in this case it wouldn't, but of course the Legitimacy Act cover a situation where the parties, the parents, if you like, marry subsequently. They don't address a situation where the parents are actually not who you think they are.
Oh, not at all. Not at all. No, I was just commenting. on
No, but you're quite
I mean, I have been incredibly puzzled by this case when I read it in your written case, because
Yes.
I knew the 26 Act excluded dignities and titles of honour.
Yes. Well, I think all of the Legitimacy Acts exclude titles and honours. There's a one exception, which is where a void marriage is subsequently
That's right.
affirmed. If the child is born after 1959, he's all right.
That's right.
But
Extraordinary
but
exception.
These
yes.
are well. It is. I mean, one peers into odd corners in the course of a practice, but
Mr. Guthrie, you were at the top of 880 or
yes,
page 24.
yes, I was, and I wasn't going to read any more of that.
No, I'm not asking you to do that. Are you going to come to how the House of Lords dealt with
I am.
the argument
Yes,
that
I am.
although he was filius nullius in 1953, he wasn't by 1977?
Yeah.
Yes, well, Lord, I was going to, before
Given the
I
point
got
that it
to
opens up afresh each time.
Well, that's...
Yes.
Well, I mean, it must be dealt with by the Lordships, I take it.
Well, I'll come to that if I may,
Right.
but if one looks at the bottom, I was going not to go straight to the decision of Lord Keith, but also to note what was also being considered. The foot of the same page, 24, 880, the respondents accept that situations can and do occur in which a person vested or apparently vested in a title or other hereditable property can be compelled to denude it in favour of another. Such successions are of two possible types, and neither has arisen in the circumstances of the present case. In the first place, there can be instances of vesting that is apparent only where the existence of the true nearer heir is unknown or is thought mistakenly to have ceased.
That's the example you gave a minute ago.
Yes.
give an
Examples would be the unexpected birth of a posthumous child or the reappearance of a shipwrecked mariner long thought to have perished.
Yeah.
Tichborne.
That's dealt with, it's quite a helpful passage in the judgment of the Lord President on page 15 of the report,
Yes.
where he gives the example of somebody thought to be dead unexpectedly turning up, and says in each of these examples, this is about 10 lines from the foot of the page, in each of these examples, any succession of a remoter heir has only been an apparent succession, and any purported vesting has been void.
Well, that is, of course, an analogy to the present case, in which the inheritance of the 9th baronet was thought to be correct, but if the evidence is admitted, was in fact not correct, because he was not juris sanguinis entitled to succeed. So it's a similar situation.
And incidentally, just above that passage, he cites McLaren on wills and succession, which is where one finds the equivalent of Palmer as to how, how in Scottish law of succession, heirs male of the body is interpreted, and it is consistent with what's said in Palmer.
Yes. Well, my lords, there are a number of points which are made in the course of the arguments.
In the end, as
Yes.
suggested, is what the House of Lords said.
Well,
Lord Keith say.
yeah. Well, before I will come to that, obviously, my lord. I just wanted to look at the argument one final time at page 26, 882.
Yeah.
The title would have become extinct in 1953. This is about 15 lines down.
Yeah.
But for the existence of the junior stirps, see Fullerton and Hamilton. One has to look at the intention at the time when the baronetcy was created. It is true that the grantees cannot have contemplated an adulterine bastard succeeding, but one must look at the language used in the deed. It is incapable of being construed so as to be capable of extending to such a person.
Yes.
And the appellant must therefore seek a construction. Well, anyway, that was the passage I wanted to look at. In Lord Keith's judgment, my lords, it's page 884, page 28, where I wanted to take it up at the foot of that page. Counsel for the appellant argued that the learned Lord President had fallen into error in laying down that it was a necessary condition of succeeding as heir male of the body of an institute, that the successor should be the heir male of the immediately preceding heir male of the body. He cited a number of powerful authorities to the effect that on every occasion where the succession opened under a destination such as this one to a title of nobility, or indeed to any other species of heritable property, it was propinquity to the institute as being descended of his body exclusively through males, which alone was relevant to the ascertainment of the person entitled to succeed. In the normal case, the successor was indeed, as a matter of fact, the heir male of his predecessor, but that was not the circumstances which determined his right to succeed. I am of opinion that the proposition embodied in this argument is sound in law, and it follows that I find myself, with respect, unable to agree with an important part of the reasoning which led the learned judges of the first decision to decide against the appellant. A little further down the page, Lord Keith also refers to the so to speak, shipwrecked mariner situation, where he says the situation cannot be equiparated to the birth of a posthumous child in the senior stirps, as to whom the maxim nascituris pro iam nator habeta applies, nor to the reappearance of a missing heir long believed to be dead. Such persons were truly entitled to succeed at the time when the succession was erroneously thought to have opened to junior stirps. So the position in the present case, by analogy, is that the objection to the inheritance of the Dunbar claimant would not apply because, in our case, the second apparent son of the 8th baronet, as to whom there is no question of legitimacy or biological parentage, was the person who was rightfully entitled to succeed at that time.
So in practice, you say you go back to the most recent uncontroversial descendant.
Well, in practice, that is what will happen.
Yes, that's what you say.
But
And you say this supports...
Well, when you say uncontroversial, perhaps begs a number of questions. Uncontroversial.
Well,
no.
uncontroversial in fact
Yeah.
that everybody accepts that he's a direct descendant of the original person.
Yes. But then one always asks the question, is the person now asserting his right to the title at this time? In other words, as we say, on the death of of any of the baronets, really, on the death of Sir Stuart in this particular case, the baronetcy is vacant, and we assert our claim to it. We say that no prescription would apply. Obviously, I'll come back to that, but we are incontrovertibly within the terms of the original grant, and conversely, Simon is incontrovertibly not within the terms of the original grant. So we are entitled, on our case, to succeed on that basis.
Well, if you're right, the death of... What is the relevance, if any, of the death of Sir Stuart?
Yes.
Yeah.
Because
If
that
you're
is
right.
that is when, as a matter of fact, the succession appears to open.
Well, is it? Not if you're right.
We've just looked at what Lord President Dempsey said about any purported vesting being void.
Yes.
So, in fact, if your client's claim is well founded, it follows that Sir Stuart was never baronet at all.
Well, that is right, Lord. It's subject, of course, when I'll have to come back again to look at the effect of the royal warrant, because it is not possible willingly to divest oneself of a title. And once entered on the roll, for all intents and purposes, he was recognised as the baronet.
Well, yes, if you get to the stage where the entry on the roll is the equivalent, for example, of a declaration of legitimacy, then you're in a different evidential situation.
Yeah.
But your case, as I understand it, is that and that's what I want to try and grasp. You've referred to the succession opening up, and I want to understand when you say it did.
Well, it did as a matter of, it must be right that it opened up on the death of the 8th baronet.
Well, that can't be right.
The eighth.
It was the 8th.
Well, sorry?
Why are you worried about the warrant? Because the warrant itself provides for corrections from time to time and issues as to whether a person is to be retained as well as a person to be placed on the roll, so that it contemplates that this sort of unfortunate issue could arise, I suppose.
Well, it does with respect, yes.
Yes, the shipwrecked mariner doesn't have to wait for the apparent incumbent to die before he can assert his...
Well, my client didn't have to wait for Sir Stuart to die. The fact is, he did. Although, no, it's not quite correct
You
to
say
say
he didn't
that
have to, because if he could establish what you say he had to establish, then he'd simply go and say, please correct the roll.
Yes, well, he could do that at any time.
understand.
I mean, he doesn't have to do it now. He could do it in 10 years' time if he so
Yes, he could do it at any time after the death of his father in 1968.
Yes.
Yes. But the situation would have to be proved as at the date that he made the claim. And that is what he says he's in a position to do. And, of course, no one would have been in a position to do until development of science and the existence of the DNA. But they are now, and the fact that the situation has changed evidentially can't alter the law. Before, on the same point, Lord, I'm sorry that you may find that your electronic bundle goes haywire at this stage, if yours is like mine.
Well, so does my physical bundle.
With the physical, you should
Duke
go
of
to
Norfolk in the middle of...
The case finishes. There's only a very little bit.
Just one page,
Right.
923.
And then we go into Norfolk.
Well, one should perhaps just quickly look at 923 because I think it's something you may be asked to look to by a learned friend. There's a sentence towards the end of Lord Keith's judgment where he says the time for the appellant to succeed to the baronetcy, if he was to succeed at all, was on the death in 1953 of his elder half-brother, the 11th baronet. At that time, he could not and did not succeed. And we simply distinguish that from the present situation because what it is referring to was a situation then when the pretender was not, in fact, the heir male of the body of the previous baronet. So he was not entitled, and indeed there could have been no reason for the junior stirps not to inherit.
And so once the junior stirps inherits, the fact that the applicant in that case later became legitimate gave him and his successors no title in the future to claim because the junior stirps had taken over.
Yes,
Yes.
Because it's very important to realise that the junior stirps had rightfully taken over.
Yes.
Because they were
Because they were the heir male
heirs
of the body.
male of the body.
Yes.
Look, I wanted just to refer to one of the cases which
Do they deal, before you leave this, with the 1977 argument or not?
not with the 90s. I'll have to come back to that if I may.
All right.
But I was going to, while one was on this particular case and the cases to which it was referred, look at Fullerton and Hamerton, which is referred to in the judgment for one saw it referred to by Lord Emsley.
Yep.
And it's under divider.
Divider 6.
Yes, it's referred to, I think, at page 870 of the Dunbar case.
What are you taking us to Fullerton or to something else? Sorry.
Well, yes. Well, can I just remind you that, without necessarily asking you to go back to the case, that on page 14 of Dunbar, page 870 of the electronic record, the
Lord President.
the President says, there is ample authority for the proposition that the holder of a title or an heir of entail in possession must always denude on the emergence of a nearer heir. And he refers to the case of Fullerton and Hamilton, which we have in the bundle at divider 6, and to two passages in it. The first is Lord Glenlee at page 439 of the report, page 962 of the electronic bundle. Where Lord Glenlee says, about 8 lines down, the rule always is that the nearest heir at the time takes the estate if something has not forfeited its right, but if a nearer heir afterwards exists, he cuts out and excludes the other altogether. He can either force the person who has got into possession to denude, or he may claim to succeed to him at his death. And the point is developed by Lord Pitnilly at page 474 of the case, page 997 of the electronic bundle. And he refers halfway down the first paragraph, a remoter heir may serve at a time when no nearer heir exists. He must denude when the nearer heir is born. He says, in these cases, this is the new paragraph, the remoter heir who has served was still alive and in possession, and the great difficulty was to deprive him of a right which he had legally acquired. It was argued that there had been an editio hereditatis, which could not be defeated by any contingency upon the rules semel heres semper heres. Such was the plea maintained, and it is stated in the faculty report to that effect. In the case of Melville and Bruce, it was considered what would happen if the remoter heir were dead and a nearer heir had come to exist. Would the nearer heir take the succession, or would it go to the heir of the remoter heir who had served? That point was argued in the important case relative to the succession of an Earl of Leven, which is reported by Lord Stair at great length. but it will be sufficient at present to notice what he says of it in his institutes. The facts of the case were briefly these: the Earl of Leven had entailed his estate, etc., on the heirs male of his body, which failing to the eldest heir female without division, which failing to the second son of Lord Rothes, which failing to the second son of Lord Melville, who had married the Earl of Leven's sister, which failing to the second son of the Earl of Weems, who had married Lord Leven's mother. The Earl of Leven left 3 daughters who died unmarried, the Earl of Rothes having no second son, David Melville, second son to Lord Melville.
Reading Leviticus.
It's almost biblical, this one, begat and begat. Yeah. But in any event, the question agitated was whether he could serve while Lord Rothes might have a second son, and it was found that he could not. This decision was overturned. It came to be argued on the bench. Perhaps I can take it up without...
We don't have to understand all the details.
No, I hope not.
Good, right. Thank you for reading. Where do we go?
But we go to the principle, which follows on the...
That's a good idea.
The principle is just this.
The principle is just this, that in tailored succession, the only question in such cases is what is to be presumed would have been the intention of the entailer. It was presumed to be the intention of the entailer, though David Melville had taken as the nearest heir at the time, yet if Lord Rothes had a second son, that the second son should take succession in preference to the son of David Melville. Now, if this rule can be supplied in a case where there is no nearer heir in existence at the time, is it not equally applicable where the nearer heir is prevented from taking the succession by some extraneous circumstances? In the present case, he was prevented by the clause in the North Berwick entail. But when that obstacle is removed, even in his own case, and more so in that of his heirs, the presumed intention appears to be in favour of the nearer heir. I am not, however, bound at present to go into the question whether you are to find that such was actually the will of the entailer in this particular case, for at present I am merely dealing with the principle and endeavouring to show that there is nothing in the idea of the supposed impossibility of the succession reverting, and that in tailored succession it depends on the will of the entailer. It therefore appears to me that there is nothing in the nature of the titles or the idea that succession cannot revert to exclude the defender's succession.
Yeah.
So if the Earl of Leven's case is right, you can not only have, as it were, a temporarily mistaken succession, which is perhaps fairly easy to understand, but you can have a temporary and as it were, subsequently defeasible succession.
Yes. Well, the important principle from our point of view, I think, is that one looks to the terms of the original grant.
Yes, I see.
And the intention of the original grant. If the intention is clear, as we say it is, the heirs male of the body, then, as we say, the only of the two before your lordships who can come within the terms of the original grant is Murray, and that Simon is excluded from it.
Where it says that the nearer heir takes precedence, does that wipe out the position in between? Does it make everything that's happened in between void, or is it only a sort of voidable situation?
Well, for present purpose, it may not matter because the decision of Lord Keith is that one looks back to the terms of the institute rather than what happened in between. It does...
the institute being?
The institute being the original grant.
Yeah.
So in other words, the terms limiting the succession to the heirs male of the body has to be judged now. And as of now, the only person who comes within those terms is Murray. So he is entitled to the succession.
Well, you say it may not matter, and in the case of a baronetcy which carries neither duty or official functions nor appended property, you might, as a matter of fact, be right. But it's not difficult to think of hereditable situations in which either an act done by somebody who you are now proposing should be declared not to have been entitled, the validity of that has to be considered, nor is it difficult to think of situations in which succession to property might have to be considered.
Well, that is certainly the case, but that, if I may say so, is a function of the law of hereditary succession. If it requires certain limitations, one of which being that you are the natural and biological son of the person who transmits the property to you.
Ruat Caelum.
Sorry?
Ruat Caelum.
Well, it's perfectly possible to conceive of situations where it might have an unfortunate result, but that, as we've put it in our case, is really a variety of a floodgates argument, but shouldn't alter, as a matter of principle, what the law of hereditary succession is.
In fact, there are. I came yesterday across Scottish cases where people have gone back literally centuries, 500 years in one case, in order to establish a right. Well, these all predated the modern legislation.
Well, I think my learned friend has referred to Richard III, and one of the consequences of that, having raised some question mark over the Duke of Beaufort's connection to him, which has been published. But I repeat, these can't affect the principle of hereditary succession, which is established. And my learned friend says that it is not necessary to prove the biological parenthood in a hereditary succession case. We submit that that is just simply wrong. And indeed, it has recently been recognized. And I was going to take you to another fairly recent case, which is Moynihan, which is relevant to perhaps more than one issue, but it's perhaps convenient to go to it now. It's under divider 16.
Yes.
1997, decision of the Committee for Privileges of the House of Lords. My lady, it's 1317.
Thank you.
In the electronic. It's in a way quite a colourful story, but perhaps I could just set the scene by looking at the head note. The third Baron Moynihan moved to the Philippines after a warrant was issued for his arrest on fraud charges in England. His first 3 childless marriages all ended in divorce. The 4th wife underwent in vitro fertilization and gave birth to a son. A year later, the Baron issued divorce proceedings against her in England on the basis of her adultery. After decree absolute was granted, the Baron went through a form of marriage with the 5th wife, who subsequently gave birth to a son. Shortly before his death, the Baron attended an English clinic to have a blood sample taken, requesting that the blood be stored for use in subsequent comparative testing with the blood of the elder child, in case the elder child made a claim on the barony. After the Baron's death, the 4th wife applied to the English court to have the divorce set aside on the basis that she had only just discovered the divorce proceedings had been instituted, and the court decided that it should be. That meant the 5th marriage was invalid, and the younger child was therefore illegitimate. The Legitimacy Act did not apply to the younger child because of the domicile. And the Baron's half-brother, that's Colin Moynihan, petitioned the Lords seeking a declaration that he, rather than either of the children involved, was entitled to succeed to the barony. A blood test was taken from the elder child, which established that he could not have been the Baron's son. The younger child relied on the Human Rights Act, and or not the Convention at that stage. Colin Moynihan won, and his petition was granted, and it was held that his blood testing evidence could be admitted. The letters patent creating the barony limited the succession to legitimate heirs. The Baron had never lawfully married the mother of the younger child. Therefore, the younger child could not accede to the barony. And then the European Convention on Human Rights had no direct application, etc. I was interested to begin with, though, in the position of the elder child, which your lordships will find dealt with by Lord Jauncey on page 116 of the report 1320. The elder child's name was Andrew, Lord Jauncey said that before the petitioner can make out his claim to the barony, he must establish that neither Andrew nor Daniel has a prior right.
Which page?
Could you just remind me of the page?
1320 electronic, page 116 of the report.
Thank you. Yep,
Subheading Andrew.
yep.
Well, Andrew had to be displaced, or at any rate, his position had to be established before Colin could inherit the barony. So we turn to consider the position of Andrew. It was fairly complicated because Lord Moynihan, the third Baron, plainly didn't think, although he had thought for a long time that Andrew was his natural son, he decided that he wasn't, and had arranged for blood tests to be taken. And those blood tests were admitted. The decision of Lord Slynn, I think I can go to, which is at page 123, letter D, and that's page 1327 of the electronic report. If Andrew is the lawful begotten son of Anthony, then he has a prior claim to that of Daniel and Colin. On the face of it, he appeared to be such. He was born during the marriage and at a time when Anthony and Edita were living together in Manila. Anthony registered the birth at the British consulate there and acted as father at the christening. At common law in such circumstances, there is a presumption of legitimacy. To decide that a child born during the pendency of a marriage was not the legitimate son or daughter of his or her apparent father is obviously a serious matter in any circumstances, and it seems to me that your Lordship's committee, like a court of law, should be slow so to decide where rights of succession to a peerage are involved. But the presumption of legitimacy can be rebutted. Section 26 of the Family Law Reform Act is then set out. Standard of proof in such cases was considered in Serio, where Sir David Keynes and Lord Justice Comyn Bruce accepted that even if proof beyond a reasonable doubt was not required, still a higher degree of proof than merely that of the balance of probabilities was needed, a standard commensurate with the seriousness of the issue involved. Is there any evidence, finds there was, Lord, the evidence which was admitted by the Lords, by the committee, I should say, showed that Andrew was, as Anthony had apparently first believed, he was not his natural son. So that.
But that's really all we get out of all this.
What we get out of this is that I'm, if you like, right when I say that the legitimacy for the purposes of hereditary succession includes biological legitimacy, and that is a necessary ingredient of it, because if it did not, then Andrew would have been entitled to succeed Anthony, because he was born in the currency of a lawful marriage, but he was not, as it turned out as a result of blood tests, the biological son of Anthony. So he would have defeated Colin Moynihan's claim if he'd been able to show that he was the legitimate child in the sense of being the natural son, which he couldn't, because it was proved that he was not. And indeed, the need for legitimacy in the biological as well as the as any other sense is recognized in a number of statutes. One's already seen that the Legitimacy Acts themselves don't apply to, in England, to...
Well, is there any other sense, or is it simply that there is a presumption of biological legitimacy?
Well, there's a sense that you can
it's
have...
quite a strong presumption, as the older cases on which Mr. Scott relies show.
Well, it was very strong until Section 26.
Right. Yes. Well, I think it was possibly slightly chipped away by Russell and Russell when that came to be removed by the Act in 1949. That presumption was...
Oh, that was a different point, wasn't it? That was what evidence was admissible.
Yes, but the presumption could be defeated. Under the rule in Russell and Russell, it could be defeated if it could be shown that conception was impossible because of lack of access by the husband to the wife.
But these are all evidential questions.
Yes, those are evidential questions. But the principle the reason I've dealt with it is because in the respondent's case, it is said that it doesn't matter. I don't have to, that it doesn't matter that Simon is not the biological heir. But we respectfully submit that it does. And the statutes which I was going to just mention in passing are the Family Law Reform Act 1987. I'm sorry, under, I think it's section 27. No, I'm sorry, it's sections 27 to section 29 of the Human Fertilisation and Embryology Act, which does apply to Scotland and to England. I've set it out, in fact, for some reason it's not in the bundle, but I have set out the relevant sections in
Yes.
Paragraph 6 of my response. The scheme of the Human Fertilisation and Embryology Act, we have it separately, but as I say, it's in paragraph 6 of my response, is to provide that those parents who benefit from artificial conception are to be treated as the mothers and fathers of their children for all purposes, but that expressly accepts the law of succession to any dignity or title, which, as we say, underlines the need for the biological element in the law of succession.
Where do we find those sections?
Well, I've set them out in paragraph 6.
Oh, yes,
but I'm afraid they're not in the electronic bundle. I have had them separately copied.
I was just, what you say is benefit from artificial conception. I'm not sure that that is accurate. I think they benefit from donation.
Lord, my lady, I have got the copies here. Mr. Lloyd.
I mean, it may include IVF as well, but so the point is the use of gametes that don't come from the supposed parents. That's the point of all of this.
Yeah, well, I think the principle then is clear enough. If they don't,
your principle,
then it doesn't affect titles and dignities. So, on that, the proposition of law we say applies is that if it is correct that the evidence is admitted, its effect doesn't seem to be really contradicted. If you apply the law of hereditary succession to the facts of this case, only Murray can come within the description of male heir of the body of the first baronet, so he must succeed. But the converse of that is also true. Simon cannot come within the description of the original grant, so he cannot succeed. That is what we should say should be the result of the reference before your lordships. Now, I appreciate that the question of evidence is going to be ventilated. My lords, from our point of view, we first of all submit that the context of the reference is important because it is not just a dispute between the two gentlemen concerned, but an investigation as to the application of the law of hereditary succession to the facts. That is a matter which would affect your lordships in deciding whether or not the evidence ought to be admitted.
So if the DNA sample had been obtained by force or however it is obtained, you would say it would be admissible, would you? Or is there any limit?
Well, Lord, I don't really have to be driven into that corner with respect. But as a matter of principle, it may be that the answer to that question is yes, it would be admissible. because it exists, it is relevant, and under ordinary principles, relevant evidence is admitted unless there is some very good reason. I could speculate as to whether what your lordship put before me would be a very good reason which would exclude it. But
Well, it might involve the taking of an intimate sample against the will of somebody, might
well,
it?
indeed, well, that was a question which was raised in the Ampthill peerage case. Roger, I haven't troubled you with that because it is decided on the very specific point that there had been a declaration of legitimacy when the question of the biological parenthood had been decided by a court. And their lordships decided that in those circumstances it was simply not open to reopen it again. So it is different to the present case. But one of the matters which was raised in argument and is referred to by their lordships is the fact that the then Lord Ampthill had been ill and some blood was obtained from him during the course of his treatment, which he plainly either didn't know about at all or didn't think had any bearing on anything other than his treatment. I think several of their lordships, certainly one or two of them, regarded that as being highly undesirable. But they did not go on to decide whether or not per se it rendered the evidence inadmissible. And they didn't have to do so because they decided the case on the basis of the previous declaration of legitimacy, which concluded the matter for all purposes. But if your lordships would be invited to say that this evidence should be excluded and the result is that a person who can be shown not to have been within the terms of the original grant is entitled to succeed to the baronetcy, then surely that is to drive a coach and horses through the law of hereditary succession. And that result should only be reached if it was, in effect, your lordships were obliged to reach it. And we say there is no basis at all in this case upon which it could be said that that result was required. Lord, there are really points raised by my learned friend, and he will no doubt develop them as he sees fit. But if I can just broadly, so to speak, predict some of them, they have been dealt with in a fair amount of detail.
As you say, we have the benefit of written submissions, cross submissions and so on, which is helpful.
Yes.
It enables you to predict with some confidence.
Well, indeed, but if one looks at the bases upon which are relied, I've already, if you like, mentioned one reason why there is no bar to the evidence such as there was in the Ampthill peerage case. And it's important to note that in this case there's been no judicial determination. It's not suggested that the
And no res judicator, yep.
and I think it's not suggested that the previous entries on the official roll give rise to a res judicata, so to speak, point. There's been no consideration of it. We would, I suppose, now leave for the future the question of whether or not there's a possibility of adverse possession or prescription, bearing in mind the matter which was raised by my Lord Reed at the outset of the hearing. But it was our position, and I hope will continue to be our position, that no question of adverse possession arises in relation to peerages.
Your point is on each, at the very least on each death.
Yes.
It comes up again.
Yes.
But at any, you say more than that, at any time it can be raised.
Yes. The cases which we would have relied on, I think perhaps I'll leave detailed reference to them for when we come back, because they're going to be subject to any further consideration. But your lordships have already seen Fullerton and Hamilton and Dunbar saying that where a person, so to speak, emerges from the shadows or a right is discovered at a later date, then there is no bar to their asserting that right. And of course, one point in this case which may be relevant to prescription is that until the results of Sir Stuart's DNA test were available, there was no basis upon which the claim could be asserted. We'll look at those circumstances in more detail in a moment. But there is no longer the rule of law preventing evidence, or any rule of law preventing evidence being given that a person who is apparently legitimate in the biological sense is not so in fact. I've already referred to the rule in Russell and Russell, my Lady Hale mentioned. The position is that the rule which precluded evidence being given of legitimacy during marriage was abolished, and it might be worth just going to the Amptill case, which is at Divider 24, Lord Simon's judgment, which one will find at 582 to 3 pages, 1568.
Thank you.
In the report. At page 1567 at the foot, in fact, at letter H,
Yes.
the Law Reform Miscellaneous Provisions Act 1949 had come into effect. Section 7 reads, notwithstanding any rule of law, the evidence of a husband or wife shall be admissible in any proceedings to prove that marital intercourse did or did not take place between them between any period. Notwithstanding anything in this section or any rule of law, a husband or wife shall not be compellable. And he says, as I have ventured to point out, Russell and Russell did no more than establish that a general rule of evidence extended to divorce cases. The doctrine was founded on public policy, which changes with social change, and it must be assumed that by 1949, Parliament was satisfied that public policy no longer required the rule in any litigation whatever. And of course, we've already seen by reference to Moynihan that Section 26 of the Law Reform Act 1969, which unfortunately that particular section has not found its way into the bundle, but you've already seen it, provides that the presumption of legitimacy is rebuttable. Now, it may not have been the law back in 1919, but it is the law now, and as your lordships know, it's our case that the situation has to be considered now. For that reason, it makes no difference that that law, for example, is not retrospective, or may not be retrospective. The fact is that there's no longer an irrebuttable presumption of legitimacy. We say that there is no reason to exclude DNA evidence, which is good and reliable evidence, and indeed it was admitted in support of Lord Moynihan's claim. Well, it suggested that there is a principle whereby the legitimation or what is referred to, we would submit possibly slightly tendentiously as bastardization of the dead is somehow prescribed. One cannot do that. We submit that there is no principle of law to that effect. If there ever was, then it predates a situation in which evidence could be produced, reliable evidence in the form of DNA.
Can I ask, under the English law relating to legitimacy, it just occurs to me that what's critical for our purposes is paternity. It's the bloodline that's important. I'm just wondering, under English law, is paternity necessarily tied to legitimacy? I mean, would it be possible for a child to be legitimated by, for example, by acceptance by the father, by acceptance by the apparent father, even though he wasn't the actual father? I mean, in other words, do you have to bastardize in order to establish that the bloodline was broken?
I suppose it could be regarded as a question of semantics. When I was talking about paternity, if the line of paternity is broken, then that is sufficient. It is also true you can be legitimized under the Legitimacy Acts without having to prove paternity. And indeed, there's of course no suggestion in this case that either the respondent or his father was illegitimate in any sense at all. Yeah. All one is talking about is a break in the line of paternity between the 8th and the 9th baronets. Mm-hmm. It respectfully seems to us, or we would submit, that there is indeed no very great stigma in a finding to that effect, dealing with a man who himself died, I think, in 1961, and who was not troubled by this in his lifetime. And it can hardly be said that his family would be exposed to the opprobrium of right-thinking people in this day and age as a result of a finding such as the evidence leads to in the present case.
A bit odd, though, that if you wait and sit on your rights and the mood of society changes and standard society changes, you're better off than if you're prompt.
Well, what can one do about that with respect?
Well, it's just a bit strange.
Well,
one of the reasons why limitation periods exist, one might think.
Well,
they want to encourage people to sit on their rights.
Well, that, of course, if that is a consideration, there is no question, we would say in this case, of anyone having sat on their rights.
Well, that's a different point, yeah.
Because I'll come to the circumstances of how the DNA sample was taken in this case in a moment, but there is
I understand that. It's a question of stale rights, really, and then there are two competing factors where somebody hasn't had the opportunity, but there's the principle of stale rights. But as I understand it, you say there's simply no prescription limitation period if you could show that you were the correct heir because 400 years ago, or perhaps one shouldn't go back beyond the Act of Settlement, but 250 years ago the wrong person succeeded, and you can, on the facts that you allege here, you could go back 250 years.
Well, that's our position, yes. Mm.
I think the answer to Lord Reed's question is that there is no process in English law whereby you can recognise somebody who isn't your child as your child, short of adoption or the deeming provisions that there are in the Human Fertilisation and Embryology Act. So obviously as the husband of a woman who is undergoing donor insemination, if you consent to that, well then you are the father. But so that can happen, but there is no, whereas I believe in some continental systems there is a formal process of acknowledgement that would override biology or could override biology.
I mean, speaking off the cuff, I think that may at least in common law be the position in Scotland.
Mm. Yeah. Of course, in practice, many fathers recognised children as their own, and they were for all purposes treated as their own, even though they weren't.
Except by the law until...
But the law presumably would certainly in Scotland, I think it treats the child accepted in the family as being someone who is entitled to financial support from the father. But that is a totally different issue. But outside that, you say the factual reality that the first annulment might have been accepted as son is neither here nor there. As a matter of law, there may have been an obligation to aliment him by virtue of the acceptance, but it went no further.
Well, it's no part of my case to make any aspersions against the 8th, the 9th, the 10th, or baronet, or indeed against any of the ladies concerned. You may have seen what I regard as possibly slightly unfortunate references to rumours.
I can hardly avoid the latter, can you?
Well, except, my lord, you say that. Sorry. But although there is some material in the form of, I think, what best described as family gossip in one of the statutory declarations about tongues wagging, which is referred to by my learned friend in this case, it's perfectly possible in this case that the grandmother didn't know who the father was. Well, she may have known there's a possibility of being more than one grandfather, but she may not have known it wasn't the 8th baronet. I mean,
Well, anyway.
I mean, one simply, I mean, it is.
We're now
I mean,
entering realms of speculation.
you see what I mean? I mean, that's why I say there's no real reason why one should enter into any of this, because all one's really considering is the question of the DNA.
Anyway, okay.
One can
I was
speculate.
just looking at Lord Simon's judgment in the Abigail Peerage case, where he delivers himself with some splendid phrases, but one of the things that he says is, motherhood, although also a legal relationship, is based on a fact, being proved demonstrably by parturition. Actually, that's not so obvious these days, but there we go. Fatherhood, by contrast, is a presumption.
Yes. Well,
Now, of course, we've got a bit beyond that.
Which page is that?
Page 577.
It's on page 571, 1562.
well, heaven knows that having looked at all this, I don't know if your lordships noticed there's a footnote that not only is there a Pringle surname project, there's also a Guthrie surname project in existence in Scotland, and for all I know there may be Hughes, Clark, Hale, other surname projects in existence. All I can perhaps say is that for my part I'm going to be a little reluctant to take part in them. But
Well, we have enough problems with the Pringle.
yes.
Well, you say it's quite simple, isn't it? If we admit we don't admit the DNA material, or exclude it for some reason, then you're bound to fail. If we admit it, you're bound to succeed.
Yes, exactly.
You were dealing with the late bastardization or the bastardization of the dead argument. I understand the submission that bastardization doesn't quite carry the same social consequences now as it would have done in the time of the 8th, or for that matter, the 9th baronet. But I think what's said against you, which I'm not sure you've dealt with, is that it's all part of a principle of not undoing long-established, accepted situations, which principle, I suppose it's probably said, also underlies the law of prescription and the law of limitation. Not simply because people shouldn't be encouraged to sit on their rights, but because long-established, unquestioned rights simply ought not to be disturbed. It's simply dangerous to everybody. I think that's what's said, and I'm not sure whether you've dealt with that.
Well, Lords, we have, indeed, it may be that this is better dealt with as part of the subsequent, the second half, if I may say so. But if one's talking about long-established rights, in this case we have a baronetcy going back to 1683. We have a question arising in those terms comparatively recently. So far as long-established rights are concerned, it's not just a question of the rights of the 9th apparent baronet, but also the rights of my client's father, who lived his life without the advantage which he was, as we say, entitled to under the original grant. And talking about affecting the rights of persons who are dead, it's not only the 9th baronet whose rights are affected, but also the real 9th baronet, if I may say so. And,
Well, that's the same point again. Yes, I see.
yeah. No. But we have nailed our colours firmly to the mast of there being no prescription which is applicable to titles and dignities.
I think my lord was asking you about presumption as well. I mean, you would accept that there is some presumption, would you, about upsetting a long-established general understanding?
Well, I wouldn't accept that applies to the inheritance to titles or dignities.
Well, I mean, I noticed that in that extract from Palmer's Practical Treatise, he refers at page 1721 to in tab 34 to a great presumption when you find the dignitary descendable at a particular period in a way that would entitle a party to take it up, and you find the claim wasn't made, or at all events the party didn't succeed, But he then says, unless there are circumstances which enable you to come to a conclusion that the circumstances of the dignity not having been taken up is satisfactorily explained. So you obviously look at the question as to whether one would have expected some other claimant to come forward at an earlier stage. And I suppose if we go back to the grandfather parental time, you've got the perhaps unlikelihood that a brother, possibly half-brother, would challenge his elder brother's title or have any reason to do so.
Particularly when he was a child at the time.
Yes.
He was.
Anyway, can I ask you a different question on the question of evidence? In a civil case, what do you say the principles are? We all know what the position is in a criminal case. Sang, there is a discretion. If it's unjust or unfair to admit evidence, you exclude it. But in a civil case, traditionally, that doesn't apply. But on the other hand, we've got the Cengiz type case, where you can get an order, an injunction, excluding reliance on evidence in certain circumstances. So it looks as if we're moving towards a situation where there is a question of judgment to be made.
Well, I think in an ordinary civil case, my lord, the CPR gives the judge a very wide discretion to exclude evidence.
Well,
and indeed, the Immerman...
Well, I'm not, relevant evidence?
Well, perhaps this is the clue to it, is whether it is relevant. It's
the CPR is one thing that doesn't apply in this case.
No, absolutely. Well, nor we would respectfully submit...
I don't think a judge can exclude relevant evidence in a civil case, normally.
No, well, I wasn't intending to suggest that the CPR had that effect. I was simply suggesting that there are provisions in litigation which appear to justify judges being able to exclude evidence. We're talking about a reference here, which is not, as I say, a civil dispute between two persons in the ordinary sense of the word. The Immerman case, which I know my lords were involved with, did not, as I understand it, in fact, reach the conclusion that the evidence there should actually be inadmissible, or that it should actually be excluded. It was left to the discretion of the judge.
It was slightly more complicated than that. We said the evidence you've got, you obtained dishonestly or unlawfully, hand it back to the petitioner's solicitors.
Yes.
They will then have to decide which of the documents you wrongly got are disclosable.
Yes.
And you have to disclose them because under the rules of disclosure in the family division, you have to disclose them. But documents that you should never have had, the solicitors hold on to.
But I think your lordship also said that it would be a matter for the judge who eventually was given the task of distributing the matrimonial assets to decide whether the balancing exercise required certain evidence to be admitted to reach a just result.
So experience suggests that one's normally the worst interpreter of one's own judgment, so I'd better listen to you to hear what you say it decided.
But I don't believe it decided that it was a very different case, so I'll come to that, but I don't believe it decided that the evidence was inadmissible full stop. But what I think I just wanted to say one more thing about the...
But it depends what you call inadmissible, really. I mean, if I'm doing a case against you and you by mistake hand me all your witness statements, it's been established now at any rate, they have to be handed back. But they would be admissible. But you simply have to hand it back, and that's all there is to it. Because otherwise it's not fair.
But the remedy, I mean, even if it wasn't handed back, you could, I think, couldn't you get an injunction to restrain someone from using certain material? And I don't know whether we're in that field here, but that at least is a restraint in a civil context. Now, it may be that this is a different context.
Well, I think it is a different context with respect, partly because it is difficult, well, it will become difficult to judge, I think, what the... I mean, in Immerman and Cengiz, there was no doubt at all that the wife's relations, at least, had behaved in a thoroughly unconscionable manner and had broken the law and had done so with the intention of affecting the proceedings. And even a strong case such as that, as I would submit, didn't lead to the inevitable conclusion that the evidence so obtained, if it was relevant and discoverable in due course, would not be admissible. So in other words, after the material had been handed to the solicitors and they had disclosed it, it would have become inadmissible, notwithstanding the fact that it had been obtained by breach of the law, subject to a discretion in the judge to decide whether he should admit it or it had to be admitted in order for him to fairly decide the dispute.
Surely, if it was subsequently disclosable, the fact that it had previously been stolen would become irrelevant.
Yes.
Well, exactly.
But it's only admissible if it's disclosable. The question which matters is whether, or might matter, is whether there is any general discretion to prevent the adducing of evidence on the grounds of the manner in which it was obtained, when otherwise it would not be.
Well, there is no such general discretion. I think the example is always given of torture, isn't it?
Because torture is a special case.
Yeah.
But it's not. So far, have you been asked to return all the evidence you've got?
No. Well, I'm going to come to the circumstances in which the evidence was got.
No. But at the end, Cengiz and Imre was concerned with no application to give it back.
Yeah.
And nobody's making an application for that, as I understand.
No, indeed. And
They've got the evidence. The only question is, can you be stopped using it?
Well, I was asked a new question. There was one further matter I just wanted to mention, I think in answer to the matter which was raised by my Lord Hughes in relation to, so to speak, situation being left as it is if it's become stale or rights have been acted on. And my Lord, it was just a point which is made by my learned friend in relation to the Dunbar case, in which towards I just have a moment to find my own place. Yes, it suggested that the Dunbar case is authority for two propositions. And the first of those, I think, is the one in which Lord Hughes was referring to. The long-standing legitimate expectation of succession to a title is not to be disturbed without compelling reason. We have said in our response that is something one can readily accept, but that there is a compelling reason in the present case, which is that it can be conclusively demonstrated that the succession to Simon is not within the terms of the original grant. And one can't, so to speak, unring that particular bell. That is the fact. And it is, one cannot, on the basis of a long-standing situation, allow a circumstance to continue which can be demonstrated to be wrong in law.
But when Lord Keith spoke about not disturbing legitimate expectations, he was speaking about the interpretation of the statute. He wasn't dealing with the sort of shipwrecked mariner situation, but he was saying that the statutory provisions dealing with legitimacy shouldn't be construed in a way which would have the effect of disturbing legitimate expectations.
Well, but the broader proposition applies to my argument, which is that if it is apparent that a situation has been allowed to develop which is wrong, then it is a compelling reason not to allow that to continue for any longer if it can be conclusively shown that it is a false situation. As I say, the fact is that when my Lord Clerk asked me about whether the evidence was not admitted, I would lose. I understand that that would not allow me to prove that I was the heir, but where does it leave Simon, so to speak? Because it simply means there's no evidence, but the evidence, as we know, has been obtained, and I shall look at the circumstances of it in a moment, which demonstrates not only demonstrates conclusively that he is not within the terms of the original grant.
Yes, but if we excluded the evidence, then
Well, he would still have to prove his succession to the registrar of the baronetcy according to the terms of the royal warrant. And we would submit that he would be now unable to do that because it has been...
it's only because of this evidence which we've excluded.
well, it may be a circular argument, but I think...
Or we would have excluded on
perhaps
that
easier...
hypothesis.
Sorry? I'm sorry, Mal, I didn't catch that.
Well, the evidence we would have excluded on that hypothesis. So I suppose he'd rely on the presumption.
Well...
There'll be something a bit odd about that.
Well, there would be something a bit odd about it with respect. And as I say, it's not, well, I'd say it's a bell which can't be unrung anymore. I mean, it's, the fact is that this evidence came into existence in the manner which I think probably time that I should turn to the circumstances in which the DNA heritage, the sample was taken. My lords, the history is set out in the cases, but it might assist your lordships to look at the contemporary documents. They really begin with an explanation by Murray Pringle of how he came to be involved in the surname project. And his statement, which was provided for the registrar, is at page 421 of the record.
Sorry, what page?
421.
Yes.
The parties were invited to set out their position for the purposes of the Lord Chancellor's Department. See that, there's a subheading, the diploma is referred to at paragraph 3. There's a subheading, a surname project, started in April 2009, originally hosted by DNA Heritage. DNA acquired the domain and database, family tree, sorry.
Sorry, what page?
Page 421.
421, sorry, I misheard. Thank you.
It really gives the background. The Clan Pringle website was created and owned by James Michael Pringle, with whom I had no connection until I discovered the website in 2008. Numerous clans have their own websites. Many of these include surname projects, and then it explains what that does. In April 2009, I became the administrator of the Clan Pringle Y-DNA surname project. During June and July 2009, I traced and wrote to about 130 Pringles, and James William Pringle, the 14th Laird of Torwood Lee, emailed more than 40 other relatives, encouraging them to join the Pringle surname project. And it was advertised on the website.
But when he says he became the administrator, does he mean that he took over a pre-existing project or that he established it?
Well, I understand that...
Well, it's the same month as the project started.
yes, it is. I think effectively he was always the administrator of it.
So it was his project.
Was it your project? The surname? Did it exist before you came involved in it? Well, I'll check that then, all right. I think it was set up, but not set up only by my client, but also by the other clan people.
No, but he was one of the originators
Yes, he was.
of the project. That's how I
I'll
read
check in
his
case
statement.
that's wrong, but that's my understanding, yes, yes. And it's perhaps, he then makes some general observations about the projects, and perhaps I can then go to page 30 of the record, where the story is taken up, so to speak.
30.
Well, 30 includes, is the consent form, which was sent. 31 is really the point, which is his first contact with the respondent. And that was some months into the project. And you'll see he wrote, "Dear Simon, let me introduce myself. I'm the son of your grandfather's brother, Ronald Stewart, your father's uncle, who went to live in Kenya in the 1920s, and he died there in 1968. I've spent most of my life abroad, recently retired to the UK, so have been able to take on the administration of the surname project. I'm writing to urge both you and your father to participate," and there's some information about the history. "You can see your family details in the Pringle website, which also have details of and instructions to join the surname project, which seeks to determine the chieftain of the clan. The last recorded chief was John Hop Pringle of that ilk, as I can. He died in 1738 without male heir. To achieve the objective, we have to trace back the male family branch lines through YSTR genetic testing to a time before the death of the last chieftain. Thus, as many male cousins as possible, preferably with documentary records of ancestry, should test in order to establish a broad baseline. The more cousins that are involved, the higher the family tree can be climbed. Additionally, the information obtained will form a genealogical record for future generations of the name." Then there's some information about the main family branches, and then the last paragraph, "The oldest remaining cadets of the Pringles of Smallholme appear to be the Pringles of Craigleith, which family branched off the main line in about 1440. The Pringles of Torwood Lee came off the main Smallholme line somewhat later, about 1475. Your father, as head of the Pringles of Craigleith, may well be closest to the name, and thus the most important person in our project. Again, I urge you and your father to join the project and take the DNA test, which consists of a simple self-administered mouth swab. Don't hesitate to call or email me if you wish." There was a further email to Simon on the 30th of November at page 33. "Further to the email below with the attached letter, I trust now you've had time to think about joining the Pringle surname project, which is detailed on the website. As the next head of the Stichill side of the family, my family too, by the way, it would be a singular honour if you should become the clan chief in due course, and indeed an honour for our branch of the family. The Lord Lion, who is in charge of heraldry in Scotland, has strict rules in regard to genealogical evidence in chieftainship claims. Now that we have the technology, the simplest and best way of providing this evidence is by way of YSTR DNA testing, which is exactly what we do in our surname project. Yes. In this regard, I quote a section from the Court of the Lord Lion's website article. I don't think I need to do that. It does say, in many cases, it's been possible for genealogical research to establish the identity of the last chief's descendants, and thus find the person with the closest blood link back to the last chief. In other cases, research is still being conducted or is now being embarked upon." A little further down, well, I think I perhaps should read the next sentence. "Once genealogical evidence has been found to identify the person most directly descended from the last chief, application may be made to the Lord Lion for confirmation that the chiefly coat of arms enjoyed by the last chief should be confirmed to such person. A dozen or so family members have already been tested, including the James Pringle, the 14th Laird of Torwood Lee. Patterns are now emerging related to the main family branches. However, we do need more Pringles to join the project. In this day and age, when families are dispersed all over the world, it is important to recognise our origins, support our unique identity, and provide continuity for the family name. And I believe we Pringles have a familial duty to work together to achieve this before it's too late. I'm copying this email to Pringles who have a particular interest in the surname project, James Pringle, the family historian, my brother, James Pringle, the Clan Pringle website owner, and James Pringle, the 14th Laird of Torwood Lee. And I've also sent a copy to your address at Platt's Farm. Then the response is, or by return, dear Murray, I apologise for a late response.
Why precisely are we reading all this?
Well, my Lord, the suggestion is made, at least to some extent, that there was something odd about all this.
Yes, I understand.
And I'm anxious to demonstrate that there wasn't.
But in essence, you ask us to read the exchanges, or
Yes, partly for
partly for that. I understand that. Yes.
partly for the information which they did make available to anybody who participated in the surname.
I understand why you want us to read.
Yes, I mean, I certainly don't want to take up time unnecessarily.
No, I understand that.
It is perhaps worth seeing Sir Stuart's.
Yes, if you want to identify any particular paragraphs, we'll read them in our own times. But
yes.
anything in the we see what's said on page 34 in the following letters.
Yes.
Emails in
I think one should probably note that at all times the prospect of establishing who should be the head of the family was.
I understand in particular why you read
there.
the italicized words on
Yes,
page 34.
and also the question of evidence, which is raised, the question of reference to the Lord Lion, which is referred to.
Well, exactly.
One of the points made is that we never explained that it might be used in relation to the baronetcy, but of course at that time it was never intended that it was never thought that it would be.
Well, could I just ask a question about that? We know from Mrs. Underwood's statement, which is MS 62, that the claimant's father believed that Norman Hamilton Pringle was illegitimate and that he was the rightful baronet. Yeah. We know that.
Well, yes. In fact, it's not apparent that that was something which was known at the time these letters were written.
Well,
I think she came.
So what I wanted to know was that evidence suggests that the claimant's father had told people of his belief that in fact his elder brother hadn't been the rightful baronet. Yeah. Is it your client's position in putting facts before us that he was unaware of his father's belief?
Well, I'm not sure if I can answer that question directly. I can certainly take instructions about it. It's certainly my instructions. It was a great surprise when the result of the DNA tests were available.
Yes, but because I mean, he may well not have known that the DNA results would have that result, but I would be interested to know if he thought they might have that result.
Yes, I think.
I mean, I just wondered whether we shouldn't be a little bit careful about this,
yes.
Because this matter has been put before us on the basis of documentation. Yeah. It would presumably have been open to either party to say that a different procedure must be adopted, and it's generally not entirely satisfactory to receive evidence through counsel.
Well, I accept it. It puts counsel in a difficult position as well.
Well, I think so, and
I see that, but there has been put before us the declaration of Mrs. Underwood.
Well, that came into being after the true position became known by the DNA.
So, subject to persuading otherwise, it seems to me that we have to proceed on the basis of the facts we have. Nobody's asked to cross-examine. If anybody wants to raise facts or inferences, which are different matters, that's fine. But as I understand it, you're relying on this correspondence to show, as far as you can, obviously we may have to hear argument about this, that the purpose of the DNA sample being requested was put, you would say, tolerably, fairly and squarely.
Yes.
And whatever may have been in your client's mind or not in your client's mind, what passed between the two parties, you rely on as representing being relatively open.
Yes. Well, indeed, it becomes.
Obviously, we may have. That's like, I'm putting words into your mouth. I'm not saying that's
the
right interpretation, but that's a different matter.
Well, one does see what the correspondence says. I mean, I mean, I understand. I mean, in fact, if an element of the Immerman decision, which your lordships have already referred to, was that there was effectively no contradiction of the fact that the wife's family had behaved in breach of the law.
Well, they effectively stole.
Yes.
Technically theft,
Well, exactly.
perhaps, but they technically stole the information, yeah.
Yes. But if there were to be, if you like, the morals of the person concerned, or the intentions of the persons that are concerned are to be considered, I would respectfully accept that one has to be very cautious about it, because it would depend upon findings as to matters which lordships are, with respect to, not in a position to make findings about. I put forward the correspondence, which, as I understand it, was all that there was at the time. The parties did not meet face to face or at any of these relevant times. I was going to refer you in particular to the communication from Sir Stewart, which is at page 36,
Yes.
which is the handwritten communication, as if you like,
Yes.
well, fortuitously, as matters turned out, making a relevant. I mean, he made a number of points. He said the project was of interest to him, but,
Yes,
but at his age, he was unlikely to see the end result of it, and he made a number of general remarks. He refers to the family tree purporting to go back to Robert of Craigleith, who died in 1513. That's obviously suspect too. I cannot think of anything else at the moment that might be useful. Yours sincerely, Stuart Pringle. And then he says, known by almost everybody as Robin. P.S. Your faith in DNA is touching, but what happens when, brackets, if, question mark, a male cuckoo enters the nest? Well, there's no reason to infer anything particular from that, except that it was in his mind. The letter in reply, dated the 21st of December, from my client, Dear Robin, good to receive your letter. Only recently on retirement to the United Kingdom that I've tried to find appealing activities such as the Pringle surname project to fill my time. I'm glad to have met, etc. Made contact. There is the last paragraph. I understand about 5% of the results are unexpected, due mainly to genetic mutations, adoptions, and extramarital liaisons. So, as you say, occasionally a male cuckoo enters the nest. However, the Pringle test results do so far appear to show familial relationships of varying closeness. Having said that, I'm not an expert. Then there's the further email, page 38. It refers to a positive letter. I'm sorry that the following emails need a bit of deletion, because the way in which they've been retrieved means there's some irrelevant material at the top of the pages, or certainly the top of page 39. It's the original message halfway down, which is
Right.
The letter to Simon, but in fact addressed to Stuart. You've successfully been added to the Pringle surname project. To log in, simply go to DNA Heritage homepage, find the login box on the left panel, and carefully enter your codes. Then there's some question about the markers. At the top of page 41, you've selected our full 43 marker test, which gives you the greatest confidence when comparing two people. The markers chosen also overlap well with others tested elsewhere and should negate the need ever to upgrade in the future. And then there's a general, any questions? The project administrator has a good overall view of the project and is the main contact between your group and DNA Heritage. They also have their own special project management pages at Oracle, and so can see the status of each individual member of the group. If you have any questions at all, the project administrator can usually answer them or pass the query on to DNA Heritage. Useful information. The project administrator for the Pringle surname project is Norman Pringle. In fact, that is Murray Pringle, who is the applicant. And then the public project administrator may occasionally wish to elect a co-administrator. Then, if you go to page 43, there is the letter from DNA Heritage to Stuart. Thank you for choosing DNA Heritage to help you connect with your relatives. You've successfully been added to the project. The project administrator, the surname project is Norman Pringle, whose email address is Murray Pringle. Then instructions about the sample. Over the page at 44, again, the same information is given about the project administrator having a good overall view of the project and being the main contact. Again, it said they can see the status of each individual member of the group. Sample arrives in February, that's page 46. And the results arrive in March, that's page 48, and they're sent to Stuart. Well, there's then a, so to speak, a hiatus, which in my client's statement, he says that was that he wasn't sure what to do when he saw the results. And it was obvious, we say, that the project administrator would be seeing and comparing the results, because otherwise the project would be pointless. Anyway, he did see, and
By your client's statement, is this the,
the
document you took us to?
yes, it is, yes.
We don't have witness statements in the...
No,
way.
well, no. Well, we have a witness statement actually from Sir Stuart, which was in the family proceedings, but we don't have what was required by the law office was a statement of claimant. So, in fact, I say that it is actually, I think, over a statement of truth. Yes, it is. So, in a sense, it's a witness statement. That's at page 12, the statement of truth. And as he says,
Page
It's not page 12.
page 12.
432.
page 12. That's the statement of that was a statement of truth.
Yes.
He says in paragraph 13, when the surname project tests showed that Sir Stuart Pringle's DNA result didn't match the result of any other Pringle, I realised that Sir Stuart could not be the chief of the clan, as he was not biologically of the clan. Inevitably, his ineligibility for the chiefship had fundamental implications regarding his and his son's rights to continue the Pringle of Stichill Baronetcy in a lineage which is not biologically related to the true Pringle bloodline. Sir Stuart Pringle's DNA result was produced on the 11th of March 2010. After careful deliberation and consultation with members of my family on the 2nd of July, I telephoned Simon Pringle, informing him that the result showed him to be a separate lineage and asking him to break this finding to his father. I just observe that there was a gap of some 4 months before Murray effectively decided what to do. If an inference is suggested that this was all part of a preconceived plan to get the baronetcy, it doesn't seem, with respect, likely that this fits in with such an inference. In any event, he wrote the letter which you see on page 51, dated the 8th of July. explains the position, writing to update you. I would have rung you first, but I talked to your son. As you know, I established the project to find the chieftain of the clan, etc., in addition to documented genealogical evidence. 43 markers, well, there were various comments on the science. I had hoped, he says in the last paragraph, that the project would underpin your nomination as chief of the clan, but this course is obviously no longer feasible. More importantly, the issue of lineage has a direct impact on the Stichill baronetcy. After a great deal of thought, I believe that it's my duty to do what I can to restore the baronetcy to its rightful lineage. That is why I'm sending you the enclosed caveat, which he did. And then over the page, see that he says, for your information, the Assistant Registrar of the Peerage and Baronetage states in correspondence to me in the following extracts, the intended effect of this is that, 1, the caveat will be entered, 2, the caveat will not preclude any person from lodging a claim to the title with the Lord Chancellor, nor will it preclude the Lord Chancellor from considering any such claim, but it will require the Registrar to give you notice should any claim be received. And in my opinion, the appropriate time for formally showing the title has passed down the wrong line is when the present baronet passes away. I think it highly unlikely that any tribunal would recommend that the present baronet be unseated. Even if the DNA evidence were to indicate an overwhelming likelihood the present baronet is not in fact biologically related to the 8th baronet, and he were to accept that, he cannot of his own volition, so far as I am aware, renounce his title. This is very much uncharted territory. I'll just note that that letter was copied to the respondent, Simon. Alistair Stewart, Ronald Pringle, is my client's son. It was also copied to Lord Lyon and to the Registrar of the Peerage and Baronetage. I don't think I need to ask you to look at the details of the results. The caveat is itself at page 56 and 57. And the response of the Sir Stewart is at the 3rd of August 2010. It's at page 58. It's, Dear Mr. Norman Pringle, if you are the person previously known to me as Norman Murray Pringle, this is my acknowledgement of the receipt of your letter. If you are not, please ignore it. But obviously it's very short, but there wasn't at that time any protest about the procedure which had gone before, or any protest that the letter which my client had sent had been copied to, among other people, the Lord Lyon and the Registrar of the Peerage and Baronetage.
Yeah.
In fact, there was some time passed before there was any sort of protest registered. Otherwise, I don't know if that's a convenient moment. It's almost 1 o'clock, I think.
Yes, that's fine. We'll resume again at 2 o'clock. Thank you very much. You're on, how are we doing in terms of time?
I think very well. I put in for 4 hours.
But particularly as we're adjourning part of it.
Yes, and I understood from your registrar that you were hoping to get away a little early tomorrow.
Well, we're starting at 10 o'clock tomorrow,
yes.
And I would hope and expect that we could finish by the short adjournment, to be honest. But we'll wait and see.
I hope that I won't be more than, say, perhaps another half an hour.
Fine. Thank you very much. That's very helpful. Thank you. We'll adjourn. We'll resume again at 2 o'clock. Adjourn.